In terms of Canada's position, we know that Canada has been opposed to the Declaration on the Rights of Indigenous Peoples. Canada is now one of two countries in the world that has failed to endorse that document. And so that, I think, is a reflection of, again, this continual denial and opposition to the rights of Indigenous peoples, First Nations people. We also see that just this past September, at the United Nations Human Council, Canadian officials took the position that the collective rights of Indigenous peoples that are affirmed in international human rights instruments, such as the Declaration on the Rights of Indigenous Peoples, are in fact not human rights. And that they also argue against the term Indigenous peoples and preferred to use the singular Indigenous people. And the thought there is that the reason for that is that Indigenous peoples really is interpreted as a collective right, and that Canada does not support that concept. So as we say, Canada has been a member of the Organization of American States. They joined in 1990. Canada has not signed on to any other human rights treaties, including the Convention on Human Rights, but Canada is bound by the OAS Charter. They did sign on to that, and that includes the American Declaration on the Rights and Duties of Man. So Canada is subject to the jurisdiction of the Inter-American Commission on Human Rights. When we think of Canada's involvement in this area of the law, there have been very few petitions that have been lodged against Canada. And when it's compared with other members of the Organization of American States, the Organization of American States is the oldest regional organization, international organization, and all of the states in the Americas belong to the Organization of American States with the exception of Cuba. So Canada is one of those. There has been, as I say, very few petitions that have been filed or lodged against Canada. There were 5 petitions in 2003, 9 in 2004, 5 in 2005, and 4 in 2006. So this low participation, how do we explain the low participation? And in fact, the Hul'qumi'num Treaty Group is the first Indigenous petition to go forward dealing with Indigenous rights to land. Well, it could be just the general lack of knowledge within our legal system by Canadians. Generally, I think Canadians do not believe that there are human rights issues in Canada, and that within the Canadian legal community, the Organization of American States, the Inter-American Commission on Human Rights, and the Inter-American Court on Human Rights are really not a major part of the curriculum and a major part of what you learn when you go to law school. So I think it really does mean that there are very few cases that go forward to these organizations. This concept of states being subject to these agreements and this international type of organizations, as is set up here for centuries, the principle of sovereignty and non-intervention in your domestic jurisdiction was something that was regularly employed by governments in the Americas, and arguing against this internationalization of rights. And for many countries, the prospect of ratifying these type of human rights treaties was seen as an acceptance of foreign intervention in domestic affairs. So the question is here, how does Canada incorporate a human rights system of Indigenous peoples into the existing legal system? And will this make a difference if this happens? I think these are important questions for us to consider. If we see that under domestic Canadian law, there's a framework of laws that deal with Aboriginal rights, including title, and that has been constitutionally entrenched, that recognition, and has constitutional protection. However, we also see that there's another area of rights, which is human rights, and that Indigenous peoples are now looking at using human rights in addition to the domestic legal system and looking at the international area. So international human rights and protection of Indigenous peoples' rights is really what we're looking at. Here we see our group that went to Washington, D.C. The Inter-American Commission on Human Rights is located in Washington, D.C. We attended 2 hearings in Washington, D.C. on the issue of admissibility. You can see in the center of this photograph our delegation. Our chiefs went with us. And then on the lower part are some of the commissioners of the Inter-American Commission on Human Rights. Our legal counsel in this case is Robert Williams, Jr. from the University of Arizona. And so, as I say, we've been to Washington, D.C. twice. The issue that we've brought before the Inter-American Commission is something that is unique to the Hulkaminum on Vancouver Island. We have a map here of British Columbia. The areas that you see in green is the Crown land in British Columbia. The areas that you see in pink are referred to as private fee simple lands. You can see that on the east coast of Vancouver Island, there's a very large piece of pink area, which is private fee simple lands. Those are lands that were granted as a result of British Columbia entering into Confederation. When British Columbia entered into Confederation, one of the issues was that they wanted the railway brought to BC. The federal government brought the railway to Vancouver, but Victoria wanted it brought to Victoria on Vancouver Island. After considerable negotiations back and forth, it was finally arrived at a solution to this, which was basically that British Columbia would grant to the federal government land on Vancouver Island. The federal government would then negotiate with a private company to build the railway, and they would pay for that with the land. So on the east coast of Vancouver Island, 2 million acres of land were set aside from Esquimalt in Victoria up to Comox. So the entire east coast of Vancouver Island, including about 90% of the Hulkaminum people's traditional territory, was part of that grant. That land was granted to Canada. Canada then entered into an agreement with an individual named Dunsmuir. Dunsmuir was the coal miner in Nanaimo. He had American partners who had built railways in California. They received 2 million acres of land as compensation, plus I think $675,000 to build a railway from Nanaimo to Victoria. And for that, they got all of the trees, all of the minerals, and ownership of all the land privately. The Hulkaminum people had no knowledge that this had occurred. And after we were in the treaty process, it became apparent that this was a major stumbling block for us. British Columbia had held a referendum. In the referendum, they asked the question, should private lands be on the table? And the answer was, of course, no, that private land should not be on the table for negotiations. The federal government, in their comprehensive claims policy, has said that they're not going to put compensation on the table for things that happened in the past. So a result of those two policies, the policy of British Columbia is that private lands are not on the table, only Crown lands, and that the federal government says that compensation is not on the table since they're not looking back, they're looking forward. It means that the Hulkaminum people are basically having to deal with only Crown land in our territory. There's very little Crown land in our territory, which has been a major problem for our communities. Our elders and our leadership have said we cannot accept the position that we simply have to walk away from 85% of our territory and that those lands are simply off the table for negotiations. So as a result of that, we considered our position and we decided that we would go to the international forum and to file a petition with the Inter-American Commission on Human Rights. After we had filed our petition, Canada's reply was, well, Hulkamina people, you haven't gone to court in Canada, and you're still involved in the BC Treaty process, which means basically that you haven't exhausted your domestic remedies. So Canada's position was, well, you have to go to court in Canada first, and you have to litigate up to the Supreme Court of Canada. Alternatively, you're in the BC Treaty process, and you should have to see whether the BC Treaty process will finally yield results.